Our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is managing an LLC to maintain the corporate veil. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. You can find us on Facebook, X, and YouTube at all of those at the handle @InRem Podcast. That's @InRem Podcast. Go there, like, and subscribe. Also, you can download an audio version of the podcast. You can go to Spotify, iTunes, Apple Podcasts, any of the major podcast platforms. We're there. Download it. Listen to it while you're doing some work over the weekend. Subscribe. We would appreciate it. With that, we'll go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is basically answering the question, what is a special warranty deed and when is it used? So what is a special warranty deed and when is it used? So a special warranty deed is a type of deed that's commonly used to convey title from a seller to a buyer in a traditional arm's length transaction. However, let me back up. I say the wrong warranty deed, so my apologies. I meant to say what is a general warranty deed and when is it used? I think I said special, so I know we're live, so there's no going back now, but I'll just back up because that's not the question I meant to answer. If you want the answer to special warranty deed, watch us next week. But what is a general warranty deed and when is it used? So a general warranty deed is a deed that's used to basically convey title from a seller to a buyer in an arm's length transaction. So most title companies will use a general warranty deed or potentially a special warranty deed. So, but the difference in what makes a warranty deed a quote unquote general warranty deed is the fact that the representations and warranties that the seller makes regarding the validity of title to the property that's being conveyed to the buyer, that it goes back all the way into time, all the way back to when the property was first acquired privately by an individual. So in Arizona, potentially hundreds of years back, the seller is basically saying, hey, look, I'm warranting to you, buyer, that I have good and sufficient title to this property, and that if there's any title issues anywhere in the chain of title to this property, whether during my ownership or any prior owner's ownership, I'm going to warranty that. I'm going to take care of that and make that good. So it's a very broad warranty deed. It's a very broad document that basically provides the buyer with the greatest amount of protection as far as their ownership in the property goes. Now, when should it be used? Well, it should be used if the buyer negotiates the special, or not, I keep saying special, the general warranty deed. If the buyer negotiates the general warranty deed, and most buyers will want to negotiate a general warranty deed because they're going to want the greatest amount of warranties, and they put that in the purchase contract that'll be conveyed by general warranty deed, then that's when it would be used. So for the most part, buyers want general warranty deeds. They don't want special warranty deeds, which I'm going to talk about next week, which have more limited warranties that I'll go into at that time. But if you're a buyer, you're going to want a general warranty deed because that is a deed that the seller is going to give to you that warrants basically title, and that there are no defects within the chain of title all the way back, into time when the property was first conveyed into private ownership.
All right. Thank you, Sean, for the legal update. With that, a reminder, it is Tuesday, and every Tuesday at 2:00 p.m., we have the Creative Finance Collective. You can find that on Facebook, YouTube, and X. We're there live to talk about creative finance. So we get together with other lawyers and professionals in the space that focus their practice on the transactional side of creative finance and what it looks like to set up that transaction from the perspective of the buyer, from the perspective of the seller. But we're there to answer questions that you might have as a listener about creative finance and what that looks like. What are the pitfalls? What are the risks? Can be some of the advantages? What are the things we see go wrong and go right? We answer all of those questions. So make sure to join us, 2 p.m. Arizona time, the Creative Finance Collective. Love to have you. And we're on as long as we're getting questions. So it's important for you to engage. We'd appreciate having you there. All right. And for today's show, if you have questions, we're going to take questions in the final 15 minutes of the episode. Make sure to post them in the chat. We're monitoring those questions now. So if you think of a question on the front half of the episode that you think is going to be pertinent and you'd like an answer to, put that in the comments right away. We're monitoring those and we will get to them. All right. With that, we're going to go ahead and get to our topic today. We've been talking about LLCs recently, but we wanted to focus primarily today on managing the LLC because it has consequences or your mismanagement has consequences in the law when we're dealing with limited liability companies and corporations. So we wanted to hone it in and focus on that. So with us to discuss that topic today is our very own attorney, Todd Lenczycki. And when I say very own, Todd is not our attorney, but we feel like he is. He's a good friend. How you doing, Todd?
I'm doing excellent. Thanks for having me on today. And I'm honored to be here. And thanks for the introduction.
Yeah, we appreciate it. So tell our listeners, if they're not familiar with you, a little bit about your practice, what it is that you focus on and do.
Yeah, so my name is Todd Lenczycki. I go by the CPA attorney. You can find me online at www.thecpaattorney. I'm not only an attorney, but I am a CPA, which means that a certified public accountant. That's what I did before going to law school. So I have a very extensive financial background, whether it's looking at books, creating companies, looking at contracts, looking at deals. I get involved a lot in a lot of cases where people are disputing their contracts and their deals, but I also have a lot of experience helping develop those contracts and deals. And I know Sean and Andy do a lot of real estate work. I do real estate work as well. I'm licensed in California and in Arizona, so I'm a duly licensed attorney. I can handle things in California, and I also do work out here in Arizona.
All right. Thank you for that, Todd. So we wanted to, we've talked about the limited liability company lots of times on this show and with you. We've gone into the LLC. As a general rule, it's the go-to company of formation for most small to medium-sized businesses. Investors love it for a lot of good reasons. But what often I think goes left undiscussed is the management side of a limited liability company and the consequences that can take place if you aren't properly managing it. So to set the table here, let's lay a little bit of groundwork for the listeners so they have an idea where we're going here. But one of the big reasons folks choose an LLC or a corporation is the liability protection. In the law, we call kind of this concept the corporate veil. But for our listeners, Todd, why don't you break down and explain what is the corporate veil?
Sure. So as we all learn and as we all see online, one of the reasons why you set up an LLC is for the liability factor, meaning my corporation or my LLC is a separate entity from myself, so that if there's ever any problem in my business or in my actions that my business takes, they take on all the liability, and me personally, my house, my family, my loved ones, all of our assets are safe because we're just owners of this LLC entity and we don't have any liability when it comes to it. So that's what we call that gap in between the LLC and the owners is the corporate veil. It's almost a corporate shield that whenever the business enters into an agreement or a contract or creates something, they will be the only ones liable for that, and it can never reach up. So I think what we're going to get into is what happens when someone tries to pierce the corporate veil, tries to go through and get to the personal liability side, and the formalities that you can take in order to prevent that.
So are there any steps that the person forming a limited liability has to take in order for the corporate veil to be established, or is it just as simple as forming the company?
Technically, as soon as you form the LLC, you have it. But as we all know, there's a lot more things that have to go into it than just technically you have it. And like, for instance, I set up an LLC yesterday. It took me about 30 minutes. I filed the paperwork with the Arizona Corporation Commission, and bang, in a few days, I'm going to be approved and I'm going to have an LLC. Oh, great, I have my company now. I'm all set. Nah, not exactly. That's where us lawyers or other competent business individuals will come in and say, you need to do a little bit more than just setting up that LLC. So what is that little bit more? We call them, in a general terms, your corporate formalities. What kind of corporate formalities do you want out there in order to really show the world that, look, we are a corporate entity. We're our own special individual person or entity that is within itself. So not to jump ahead, what are some of the things that we can do as the corporation in order to establish those corporate formalities? The first thing is obviously registering as an LLC, getting set up with the proper registrations with the Arizona Corporation Commission or the Secretary of State if you're in another state. Get those filings done, get them done properly, get them approved. That's step number one. Step number two is you want a bunch of agreements behind those, whether it's your articles of incorporation if you're a company, but we're talking about LLC, so it's your operating agreements and those type of things that will basically establish what are the rules of the LLC. Who are the directors? Who are the shareholders? What happens when a decision needs to be made? Who votes on it? And all of those things. So you can find standard operating agreements online, but I would say talk to an attorney, tailor it your own way, get that operating agreement in place. And this isn't something that you share with the world. This is something that you create internally so that when things happen, you can refer to it on what to do for your own sake, but also to show the world, if anyone ever calls and tries to pierce that corporate veil, look, I have agreements in place that show my formalities. Would you like me to?
Let me
Sure.
let me follow up with something here. So I'm thinking, Todd, of every business owner that I know and every entrepreneur that I know. In the early days of the business is when they've got the most juice. That's when they're ready to go. We're starting yesterday kind of thing, and we got to get this moving. And that's where they give it their most attention. How do you kind of counsel the entrepreneur, the investor, the business owner, to pump the brakes so as to, get the proper corporate formality going before they go too far or step in something that they shouldn't step in?
So when I work with a new entrepreneur, I basically package it all together. I basically say, look, we're going to do this, that, this, and this, and it's all together in one package. But not everyone has the luxury or the affordability to hire an attorney. So I think we've discussed this before, and I know you talked about it on your show. You want these documents because you're going to need them in the end. You want to have everything locked away and done properly. So just as enthusiastic as you are about starting your new business and getting that first sale through the door, you need to be equally enthusiastic about getting these operating agreements. I think another thing that you can do is setting up, your books and records, getting a good accounting system in place so that you're able to record that first dollar that comes in. And then, getting a hold of, proper licenses with the city, getting everything into that corporate name. You don't want to use your name anymore. I'm no longer Todd Lenczycki. I am the CPA attorney, LLC or PLLC, whatever you are. And you want to start getting that attention and bringing everything in, even if it means switching accounts, starting new accounts. You want everything in that corporate name. So what I would tell, or to answer that question, is, you need to do it, because if you don't, you're going to face this problem. And the main reason why you set up that LLC is for that corporate liability to be held within the corporation. And you would hate for it to be, your personal house on the line because you struck a bad deal.
Well, let's talk about that. And you mentioned this, concept of piercing the corporate veil, and we hear it thrown out there a lot. But what does that mean? If you have an LLC and you believe that they've wronged you, let's say you're a plaintiff, you've been wronged, and your attorney says, "Okay, let's pierce the corporate veil." What does that mean? Right? What's the result, and what does that look like?
Yeah, exactly. So what's going to happen is the complaint is going to be filed, the lawsuit or the demand is going to be made not only against your corporation, so LLC, it's also going to be made against the owners of the LLC. So it's going to be named against John owner and Jane owner as well. And what the lawyer or the plaintiff or the person trying to get resolution is trying to accomplish here is they realize that maybe the corporate entity doesn't have the ability or the assets to pay off my judgment, meaning they just borrowed $10,000 from me and they just blew it on lottery tickets as opposed to spending it on buying that piece of equipment that they needed. Well, guess what? If the company just blew all their money on lottery tickets, they don't have the $10,000 to repay you. So a good plaintiff or a good plaintiff's attorney will say, well, who has the money to pay you? Does this company have insurance? We'll get that involved. But more times than not, they'll say, look, this company is not really a company. It doesn't have those formalities. So we are going to go through that corporate veil and get to the owners who have all of the money or at least bigger pockets to satisfy our judgment from. So a goal as a corporate attorney that establishes a company is you want those formalities in place. You want those instructions that we're going to probably get to later about funding, capitalization, those type of things, so that all the liability sticks within that corporation and it doesn't sprout out to the owners who obviously started the corporation to avoid that liability.
So is what you're saying is I'm a member of an LLC, maybe, there's 5 of us that own an LLC, and that LLC enters into a contract in the name of the LLC, maybe a lease, right? And I don't personally guarantee it. So I'm thinking, great. The LLC enters into it and then they default and now they owe a bunch of money on that lease. The LLC owes. There is a chance potentially that I'm going to be dragged into the lawsuit and be held personally liable.
Absolutely. I don't even think there's a chance. I think it's more than likely that you will. And you better have a defense attorney that will quickly put an end to that and file a motion to dismiss and say, look, I'm just an owner here and I have the corporate liability shield and the lease was entered into by the company. So dismiss me as a defendant because I'm not on the hook for this. And, that's the whole purpose of the corporate veil and the corporate shield.
I wonder, Todd, I want to see what you think about this, but I wonder if the rub where a lot of folks get this wrong conceptually on the front end, which might get in the way of helping them to approach this properly and give the LLC or whatever entity it is the respect that the law says that it deserves, is that while the law treats the LLC as its own separate person under the eyes of the law, it does. It treats it as its own thing. I think we as individuals don't tend to give it that kind of treatment. We think it is as just another name for stuff that I'm already doing. And conceptually, it kind of feels that way, right? But the law expects you to treat that as if it's another person. I mean, look, we have formalities that go into the bringing into an existence of a new human. At birth, we're assigned social security numbers, we're given birth certificates. There's a whole number of formalities that we do. We would never share bank accounts necessarily with our adult kids as they go on. There's a process. And I think as soon as individuals realize, look, this entity is its own separate thing in the eyes of the law, and it has to really be treated like that. Do you get a sense, or have you seen with clients a difficulty in even appreciating that on the front end?
Oh yeah, absolutely. I mean, one of the things, the corporate veil of how you pierce it, is the concept of an alter ego. So, a lot of owners, especially sole owners or a family that owns one business altogether, they really do treat their company as themselves. Yes, it probably owns their family car. Yes, it probably owns some assets that are used personally. They know they probably shouldn't, or they should better keep better records, but they do just treat it as their right arm. They treat it as a member of themselves. And as that progresses, or if that is done too often, and as the plaintiff lawyer that I am, you're treating your corporation as your personal piggy bank, which means that, you're using it just as any other asset that you own personally. There will be a tax on it when that corporation or that LLC is unable to pay. So answering your question, of course, it's your natural inclination. I walk around calling myself the CPA attorney. So, of course, I think it's an element of myself. But do I have my own books and records? Do I have my own bank account? Do I have my own EIN number? Do I have an operating agreement? Absolutely. It's all there. Do I hold shareholder meetings? That's one of the things that, it's as simple as drafting something up and saying, December 31st of every year, I meet and everything looks great. And we re-updated our corporate filings, and I write it in writing, I print it out, I sign it, I put it in a little book, or I store it electronically. All of these things that you can do to show that your corporation is a separate entity and is being treated like that, at least formally, and you're attempting to do that, is what a good attorney or someone that's representing you or someone that's advising you will look for and want you to have in order to keep that corporate protection.
It's as almost as easy as if you treat your company like its own separate person, then the law will too.
Exactly.
I mean, that's the bottom line, right?
That's a great way to state it. And I'm sure we'll get into loans and pulling money out of your company and how do you do all of that. That's what the importance of documenting, having separate accounts. I have a business account. It's only owned by the CPA attorney. And the CPA attorney then makes withdrawals to pay its bills and to pay its employees and to pay its independent contractors. And all of that comes on its own check stock or its own, those type of things, where I think you stated it perfectly, Andy. If I treat it that way, others will be forced to do so as well. And that's what I'm looking for.
So you laid out a few things already, items of evidence that presumably somebody would use for, to establish alter ego status. So let's break some of those down. So the first thing that you mentioned was, having a car in the name of the business that basically you use as your personal vehicle. What is kind of the rub on that, or the rule on that? Because I know a lot of people put their vehicles in their company name because they think that there's a tax benefit, whether there is or isn't, I don't know, but they want to do it that way.
Sure. So how do you pierce the corporate veil? One of the primary ways that you do it is the showing of commingling of assets, meaning that you take business assets and you use them in your personal life, or you're using personal assets for the business, and the business is not adequately compensating the personal person that put them in. So it's the commingling of assets. So if I wanted to buy a car and I'm going to use it 50% times for my business, yeah, I'll buy a car and I'll put it in the name of my business, and I will keep a mileage book, or I will keep some type of record where here are the miles that are used for businesses, here are the miles used for personal, and then the payments and the repairs and everything that goes with that asset should fall in line with that usage status. So it's just making sure that you're not commingling assets. And how do you commingle? You have one bank account where my earnings from my spouse go into, and my earnings that my business go into, and my business pays stuff out, and I'm paying my home mortgage out of it, and I just bought a new boat and I just put that in there as well, and it's all out of one account. Well, guess what? I don't care how good your records are and you're keeping track of everything, every debit and credit. Just get a separate bank account. Don't commingle your assets that way. It's not that hard. Go to Chase Bank. They'll probably give you a bonus for setting it up, and it'll just make things so much easier. So commingling of assets is the major problem. I wrote down 3 or 4 of them here.
All right, let's hear the other ones.
So the other one is undercapitalization. What you don't want to do is set up a company and then don't give it any money to operate. It's basically a shell, and the law will see right through that. I mean, piercing the corporate veil, as we just heard about, it's actually a pretty difficult concept to do, meaning you'll read in the world of the law that, oh, we're not going to do it in this case. It's hard to do here. But if you don't follow, like if you commingled your assets and you undercapitalize your business, meaning that your business has no assets on its own, or it has no ability to pay things without getting infusions of capital from yourself, and then as soon as the money is made there, it's quickly pulled back out, back to yourself, that undercapitalization is going to be looked at as, look, this really isn't a company operating on its own. It doesn't really own anything on its own. It's perfectly just set up just to prevent liability getting back to the owners, and the undercapitalization peg will be met and will pierce your corporate veil.
What's
some other ones that I have: fraud or illegal acts. If you're just setting up your company to defraud people, and your thought is, well, guess what? It's in a company, so only they're going to be liable for it. Your company is going to be shot down. I'm doing a case out of Nevada right now where a shyster, a fraudster, set up a whole bunch of companies, and he just started just scamming people out of them. And his thought process, and granted, it's hard to get a hold of those people now, but his thought process, I imagine, was, well, I set up a company, so I'll never be personally liable for this. And it doesn't work like that. If you're just setting up a company to take advantage of somebody, or to perform an illegal act, or even perform an act that you know isn't going to work out well, meaning I just signed the 5-year lease knowing that I'm only going to use that building for 1 year, and you set up a corporation just to do that, it's going to be shot down as being done primarily to do a fraudulent or illegal act. The final one, if we already hit on, is just failing to follow those corporate formalities, meaning not setting things up properly, not handling things properly, not having the separate book, not having the separate bank account, not getting the licenses in the name of the company, never sharing things with the company and putting it in its company's name. All of those things are the 4 things that you have to watch out for.
So let's jump back. I just have a question, and this thought occurred to me while you were talking about the idea of using, your personal resources for your business without proper compensation. Well, since COVID, a lot of people just work out of a home office. And so, they might have an LLC, and, maybe it's a contracting firm, and they're a contractor, and their office is their home office. It's all set up at their house. They use it. There's no lease signed with themselves individually. There's no payment made from, the LLC to them individually, but on all of the books and records, the corporate filings, everything lists that home address as the address for the LLC. Is that a problem?
I'm not the real stickler. I don't think you really have a problem with a home office. So I wouldn't worry about that. I wouldn't have the lease for 120 square feet and I'm paying you $2 a square foot and I'm switching money like that. But the talk about where I'm saying that you should do something more formal. Let's say I want to give $10,000 to my business and I don't want more equity in it because I already own 100% of the thing. I want this repaid back as a draft up a loan agreement. I better put a reasonable rate of interest in there, and I better loan my company the $10,000, see it move from one account to the other, and then I better be paying on that loan as you would any other type of thing. That is the separation that I like to see. Just working out of a home office, sure, you can set that all up, but just because you're using your home address as your business address doesn't mean all of a sudden your home is on the stake of being a business asset. I wouldn't go that far, and I don't think any legal system would either.
So let's jump into some of these specifically and what it looks like to act properly, so as to not have the corporate veil pierced. And we'll start with kind of what we've been talking about, the broad term of keeping corporate formalities. That means a lot of different things, but the formalities of having a company, I think it starts with properly forming the company. It's hard to imagine getting that one wrong. I suppose you could. I mean, they make it so easy now. I suppose you could just forget to hit the final submit button with the Corporation Commission, and it doesn't get approved. But it would seem to me that if you continue following the corporate formalities of getting a bank account, that would get caught and fixed, because they require that. But I think it probably starts with forming the company properly. What next? Do you need a EIN?
Yeah, absolutely. I would go out and go to the IRS, get your EIN number, get the registrations that you need. For instance, an accounting firm needs to be registered with the state of Arizona as an accounting firm. A law firm doesn't actually, but other types of places. If you're a professional construction company, getting your registrations, going to the registrar, getting your registrations and your company name. You talked about the formalities of forming it. I think you're exactly right, Andy. Everyone does well forming it. It's just maintaining it. A lot of states, Arizona's lucky. You start an LLC and it's kind of like set and forget it. There's a lot of states out there that every single year you got to file a statement of information, or you got to file some type of other filing that says, look, I'm still an LLC and I'm still going forward, and my agent hasn't changed or my address hasn't changed. And it's, of course, it's a money grab. It's just to get some money out of you every year. But following that corporate formality, I think, links into formation, keeping your annual filings on proper, keeping them up to date. Bank accounts, starting that bank account, that's very key. Getting your own bank account in your own company name. The other things that I have written down here, because I knew you were going to ask this, is try to establish a separate address. We talked about that home office address. That's perfectly fine. I know a lot of corporations will just go to a UPS store and get a UPS address, get a PO box somewhere, or some people even go as far as getting their own office space, getting a Regis office space or something like that. If you're able to afford it, or you think it's good for client relations or optics, doing something like that will establish things. Minutes, corporate meetings, shareholder meetings, resolutions, those type of things, meaning all of a sudden the company has a big issue that has popped up. We want to bring in another member. We want to reward an employee with becoming a part owner. Document that. Hold a members meeting where you actually write down, you can get these forms online. A lawyer can provide them to you where you fill them out. At least have a regular annual meeting, whether it's, at the end of the year or end of a significant event. Have those going forward.
Well, the other consequence to all these, beyond just piercing the corporate veil, if everybody's thinking, well, that just sounds like a lot to do, and especially if it's just the mom and pop LLC. But, the second you try to go get lending or whatever else, the lender's going to ask for all of those things typically.
You're exactly right. Another thing I just wanted to mention is, like we talked about, your bylaws, your articles of organization, just getting those set up. And another key thing is just reviewing those. Even if your meeting is just, I reviewed my corporate, my corporate bylaws, or I reviewed my articles of organization and everything was set and we reapproved them, or we, had to make a substantial change because of our address change, just doing that kind of stuff and having it there in real time. Yes, it's a pain in the butt. Yes, it seems like overkill. And trust me, I'm not a procedural overkill kind of person, but if you are doing some dangerous practices, meaning anything can be dangerous, you're helping someone out that you think might sue you someday. You have, you're building a building, and I know you're going to do great work, but you're going to have issues with paying people, or people not wanting to be, people causing problems, filing complaints against you. Having all of this in place, you'll make a defense attorney's life a lot easier when you show them that file, and a thing of relief will come across both of you guys as you're going through that.
So let's talk about operating agreements for a minute, because once again, Arizona is unique in some ways. Although I think the Model LLC Act, or the Uniform LLC Act, has been adopted, throughout much of the country, which we have a kind of a modified version of it here in Arizona. But in Arizona, our statutes state, hey, if you don't have an operating agreement, then our statutes will kick in and basically act as your operating agreement. So how critical is an operating agreement, at least here in Arizona?
I still think it's very critical. You don't want those default provisions, because when you start looking at the default provisions, that means that you probably have a problem with a co-owner or with somebody that's, trying to do something on that corporate level that you used to be a partner with. And sometimes the default provisions isn't exactly what you guys agreed to. So get your agreements in order, and you'd be surprised what can be pieced together as an operating agreement. Meaning, even if you don't have one officially, an email between you and your partner where you said, hey, we're going to split expenses 50%, 50-50 each way. The court's going to look at that as an operating agreement, or at least interpret that provision as being part of a larger set of operating agreements. So why not just put it all in one place and just get it all signed so that you know where to look and you can just go from there?
What if you're just a mom and pop operation? I just form an LLC. It's just me and my wife. Do we need an operating agreement to keep, the corporate formalities in place? And
like I said, you don't technically need it. You probably don't need it, but put one together. Do it if 6 months in. To just get one together, put it on your to-do list, and get it together. Like Sean, as you've been stating, it's not absolutely required. No one is going to check for it. No one's going to ask to see it. But when you're going to want to rely on it, you're going to wish you had one. So that's what I would tell you.
Yeah, and I've seen a number of cases where, again, dealing with third parties like lenders, even when you're just a sole owner, they're like, "Where's the operating agreement?" And they call me and I'm like, well, they're like, we didn't do one. Is that a problem? It's like, well, no, that wasn't, against the law or anything. You're allowed to not have an operating agreement. But, lenders that lend in all 50 states, they don't have the time to worry about which ones allow for what. They want to see operating documents, and it lends, or it gives legitimacy to the business. It's in some cases, it's still a good look and something that you want to be able to present. All right, so let's jump to the commingling of funds. You had mentioned it before, just a real easy one to get wrong, whether it's intentional or inadvertent. It's one of those ones that it's easy to do inadvertently. So let's start here. What do you do if the LLC needs money? How do we start with this? Whether it's right at the beginning of the business or further into it, usually it's going to be at the beginning. What does that look like?
Sure. So the owner has to infuse capital into it. I mean, that's plain and simple. It needs money to operate. It needs money to pay its bills. So you set up your accounting ledgers, whether it's in QuickBooks or you're paying an accountant to do it, and you just basically write a check into the company's business account, and you identify it as a contribution of capital. That's why you're the owner. That's why you put it in there. If you want to be extra special, put some minutes together and say, I just contributed money to this business. But I think, Andy, what you hit on great is it happens inadvertently. That's the way it really happens, is when you're commingling funds, is, you go out to eat, and that company credit card that you always use just to pay all your business expenses accidentally gets put on the table for a personal expense. You just don't fret. Your corporate veil is still attached, but just make sure that your accounting is done properly. When that bill comes in, that bill is separated out. That $47 for whatever pizza with the family is written off, and a capital contribution is made in order to pay it, or the bill is just, taken off the ledger. What you don't want, excuse me, and what you don't want to see is Pizza Hut with the family on your business records as meals 7 days a week. Not only is that unhealthy for you, as people will tell you, but you don't want it. It's not healthy for your business either. That when you start looking at your corporate ledger and somebody puts it together and they're quantifying your credit card charges, and it's all of the things that you've been spending personally, that's when you got to take a step back and say, look, I am not honoring what I should be honoring. I don't want to have to show this to someone and say, oh yeah, I'm not going to pay you from my personal funds because I breached that lease, but I have been paying my personal funds to take my family out to eat. That's not going to jive well. And it's things like that that are going to get you in trouble. So the way that I say that you prevent inadvertent expenses or things like that is just to review what you've done and correct it when you see it. Definitely correct it on a going forward basis. Try to correct it in the past. It could just be some accounting journal entries. As a CPA, it seems easy to me. I get it. It's not easy for everybody, but just keep an eye out for it. Be recognizable about, where money is going out and how is it going. And that's why keeping a separate credit card, a separate bank account just makes it so much easier. And it's almost what is required.
So, and I think we've all seen it. There are business owners who don't want to have any money in their personal name. In fact, they might even brag about it. Like, I don't have any money in my personal name. And they're basically putting the tax issues of that aside, but they're basically paying literally everything out of their business. Their credit card statements come in, their personal credit card statements come in. They're paying it. They're paying their boat payment. They're putting the boat in the business name. They're basically everything. They're paying their mortgage payment. They say, well, my business operates out of my house, so I pay the mortgage, and they basically do all of that. That's a problem, right?
Yeah. My question to him would be why? I think I have a nephew that says why though all the time. Why though? Why are you doing that? I mean,
right.
It makes no sense. I mean, you're essentially, if that's how you want to operate your life, first of all, the IRS is going to, when you start filing your tax returns, all it takes is a random audit and you're going to have a lot of problems. Second, where are you putting ideally, you want things personally, because Todd Lenczycki, the person, is a clean shooter. He's not going to do any fraudulent contracts. He's not going to do anything like that. I want my assets in my personal name, not only to build up a credit history, build up those type of things as a personal thing, but my business is where my liability is. That's where I'm dealing with others. So I get it. The one person wanting everything in their business for the tax write-offs, you have a problem not only with the IRS, because a lot of that stuff isn't tax write-offs, but you're really subjecting all your personal assets now to whatever that business does. And then the opposite is also the true. If nothing is in your business and it's creating all of the liability and has no way of paying for it, well, then they're just going to go off. So like everything in the world, you need a well-balanced idea that's based on reality and based on fact, meaning you live in your house, so your house is paid personally. Your business address handles your business, so that's paid by your business. Just take a step back and use logic, use common sense, because that's how everyone else is going to look at it. And if it's part of the business, keep it in the business. If it's part of your personal life, keep it in your personal life. If it's a halvesies situation, figure out a ratio of the halvesies and follow it, and document it and follow it.
Now, beyond the question of commingling of funds, you mentioned, we've kind of jumped into it a little bit, capitalization or undercapitalization as being a problem. Is the fix or the way to avoid undercapitalization just as simple as capitalize the darn thing?
It is. And I'm not saying that you have to have a bank account with just $10,000 sitting in there. Of course, nobody wants that. Distribute it out to the owner and use it properly. But don't allow the company to become undercapitalized, meaning if the company is dying and it's going to be going under, you don't have to just keep on infusing capital in it, trying to keep it alive. That's the reason why you have a corporate structure. Is your business, unfortunately, didn't work out the way you thought, it's allowed to fail. It's allowed to go under, and creditors are paid off. The undercapitalization comes along when you're doing a large deal and it's going to take this amount of money. And instead of leaving that money in the company because it's already has it, you pull it out for yourself. And you just say, oh, yeah, you're right. I just signed that big contract where I have to contribute labor and materials, and it's going to cost $50,000 of my company. And my company just made $50,000 last month to afford it. But I wanted to pull the $50,000 out to buy my boat instead. That's going to be the undercapitalization that they're going to look at and say, why did you enter into a contract when the company had the ability to pay for it, but then based upon the owners taking money out of the company, it made the company unfunctional, made the company insolvent. So if the company can't pay its own debts, that's fine. Let that happen. But if you, the owners, are doing something so that the company cannot pay its own debts, meaning extracting money out of the company when you shouldn't be, that is when the undercapitalization problem will come on. And that's when the law will look to those and see what was going on and try to grab back that money. Maybe it's not going to pierce the corporate veil completely and say, Joe owner, you're responsible for everything now, but it could very well say, hey, that $50,000 that you pulled out for your own self beyond your salary just because you had it sitting there and it was needed for company, liability A, they're going to, if that's what tips your company over, they're going to try to claw that back.
What about the circumstance of what I would call a reverse pierce, meaning the LLC becomes liable for my personal debts and obligations? Can that ever happen? If it's an alter ego and I go out and I cause a car crash, that results in serious injuries or death, multi-million-dollar claim, can they then go and get a judgment against my LLC if I'm not properly managing things?
That's an interesting question, Sean. I don't know the answer completely, but I would say no, it is a separate entity. Now, granted, if you are operating as the business, meaning you're the Pizza Hut driver and you're using your personal car to go deliver the pizza and the car, causes a problem, yeah, Pizza Hut's going to be, your Pizza Hut franchise is going to be liable for that. I don't know why I have Pizza Hut on my mind, but I just do today. But the reverse, the way I would see the reverse thing happening, and when you were talking about it, it's that guy that's putting everything into a corporation. It's the guy that's, I have a corporation for this, and I put all of my personal assets into it, even though I'm using them personally. I think then when you have that personal liability, they will look to that corporation that's being used, quote unquote, as the corporate piggy bank, as your personal, money pad that you would have to then be able to go in there and do it. I think you would have a logical legal argument to do that.
Todd, so let's break down one of the final ones, the fraudulent transfer. Asset planning after there's a dispute oftentimes is what that can look like. But what is it and why is it a problem? And you had mentioned earlier that, that's a reason to be able to pierce the corporate veil.
Sure. So a fraudulent transfer is exactly kind of what it sounds like. You're transferring assets out of the entity that has the big liability in order to protect them, meaning, I owe a judgment. I messed up on a contract and now I have to pay up. Debtors like to be paid. Courts want to see that debtors get their fair share, creditors like to be paid from debtors. Creditors should be able to be given their fair share of the amounts that they are owed. So if you are deliberately and with the intent of taking assets out of a company in order to avoid paying a creditor, the court will not be happy with you. If they find that out, they will definitely claw that back and say, look, and they might even infer intent. Maybe you didn't have the intent, but they're going to infer the intent of saying, you paying your sister all of a sudden, who is now on the payroll, a large employee bonus because you didn't want $10,000 in your bank account when a garnishment was going to come through. They're going to look at that if they find out about it and say, this just doesn't seem right, and they're probably right. And you could have the best intentions of the world. Oh my gosh, my sister just had a birthday and I want to give her $10,000 and this is a way to do it. They're going to see right through it and say, no, you got to pay your creditor. And the law allows for those clawbacks. You see it especially in bankruptcy. That's where I come across the concept all the time. I'm not a bankruptcy attorney, or nor do I profess to be one, but you see it all the time as a company is about ready to go under. It's been slogging along. It's about ready to fail, and it's finally going to fail, sadly. But then all of a sudden, right before it does, boom, all of its assets disappear. Things are liquidated. Things are sold. Things are just going back. And that's not fair to the creditors. All the people that have financed or given loans or provided services to that company to have nothing there for them. So the court will go back. They will analyze the whole situation. I usually, in a bankruptcy court, I think they go back 2 years or something like that. And they will look at all those transactions. If they're not justified, they'll go on back. And that's just the law.
I've always thought it's a great way to ensure your family members get brought into a lawsuit. You know, you transfer the property to grandma. Even she's going to be the transferee, she's going to be brought in.
And people try it. It's crazy.
Oh, yeah.
People try it.
Oh yeah, always a problem. Well, Todd, we really appreciate you taking the time with
Absolutely.
us to discuss piercing the corporate veil. Tell our listeners how they can find and connect with you.
Sure. So the best way to reach me, as always, is my email address, contact@thecpaattorney.com. I have a phone number on my website as well. Feel free to call it. I'll answer it. Yeah, I'm one of the attorneys that does that. I'm gladly, provide you those things, but through the internet, through the email, that's the best way to get a hold of me. I appreciate it. Everything that you guys have done. I know I get a lot of contacts saying, I saw you on the podcast. I saw you, as a referral source. So thank you so much. And I'm glad to help out, and I'm glad to be here. So thank you.
Well, we appreciate it. Good discussion. Let's do it again soon, Todd.
Absolutely.
All right. With that, everybody, that is our show. Make sure to join us next week. We'll see you then.
Have a good day, everyone.